Now I'd like to introduce Robbie McLellan to speak about legal trends. As partner and counsel at MLT Aikens, Robbie advises a variety of public and private sector organizations on corporate governance and compliance matters. He has extensive experience in the area of construction law and assists clients to effectively plan for and execute construction projects from conception to completion. He also helps clients with dispute resolution strategy and compiling occupational health and safety and environment programs. Robbie joined us at last year's conference, and we are very pleased to have him back. Over to you, Robbie.
Good morning. Thanks, Kelly. Just double checking everybody can hear me. I'm hoping so, and I appreciate that. Hello, everyone. My name is Robbie McLellan. I'm a partner in our infrastructure and construction projects group in Saskatchewan, based out of Regina. Despite running far too long last year, I have been kindly invited back to present another conversation on emerging legal trends that are relevant to both Saskatchewan as well as particularly the safety the safety concerns within the industry. I will do my absolute best to stay on time today, and it's always a risk handing a microphone over to a lawyer, as we do sometimes get wordy. I think Kelly did a great job directing everyone to the comment section. I'll keep my eye on it. If anybody has any questions on any particular slide, please make mention of it. I'll do my best to answer those questions in real time, and if I miss it, we'll try to reserve some time at the end to answer any types of questions that are popped into those comments section. So the two main points of discussion for today's presentation relate to, first, the emergence of collaborative contracts and different contracting strategies within Western Canada, and most particularly Saskatchewan, and how these different collaborative contracting strategies may give rise to different opportunities for how the health and safety obligations on projects, most particularly within the commercial construction sector, be addressed between owners and contractors. The second point of discussion was specifically requested by the organizers, and this relates to drug and alcohol in the workplace legal updates, where we are going to analyze on a very high level the current status of the law for drug and alcohol in the workplace, but also particularly analyze one Saskatchewan case published in the last 18 months, which may be worth discussing and has some lessons for us all to learn. So moving first over to collaborative contracting. What do we mean when we say collaborative contracting? Well, we all understand that traditionally large procurement, both publicly and privately, has involved some level of competitive price competition, typically hard lump sum bidding. Although once thought as a clear path to best value pricing, we now know that hard bid competition may not always lead to best overall project pricing. However, collectively, we understand that it at least leads to market reasonable pricing and accountability, the latter being a fundamental and critical cornerstone of public procurement and a focus of most governments. However, across all sectors, pervasive cost overruns, schedule delays, and high-profile contractual disputes are redefining the relationship between public sector project owners and contractors. The increasing scale, scope, and complexity of capital projects and programs has greatly intensified the risk and reward from the fixed price, date certain nature of traditional contracting models. Even more impactful to the current state of the infrastructure and construction industry in Western Canada is the intense competition between projects, which may have given the blue chip and large contractors ample choice as to which projects they pursue, and overall creates potentially less competition within any type of procurement situation. This concept has translated to projects with less risk and less front-end investment being favored over traditional, expensive, and risky pursuits. On the same notion, the race to the lowest price within the traditional procurement methods, often with major project risks being ignored therein, misunderstood, or underestimated in bids, has resulted in contractors seeking to restore profitability through claims or change orders during the delivery phase, much to the immense pain to everyone, well, except lawyers. In response to the challenges, one key practice that is gaining momentum is adopting a more collaborative approach to project planning and delivery, including harnessing collaborative contracting methods. So what is it? Really, as we define collaborative contracting, it's an opportunity and a strategy to work together from the start. Collaborative contracting methods can provide early contractor involvement for the benefit of technical and commercial planning of a project. Early contractor involvement can improve project outcomes by harnessing a contractor's input in the overall scoping of the project, including managing and mitigating project risk and uncertainty. It facilitates identifying cost and schedule challenges early, analyzing potential design and scope adjustments, schedule challenges, as well as carefully considering the role of third-party stakeholders, all supported by open book, transparent cost estimates and construction experience. Early contractor involvement enabled by collaborative contracting is a true attempt at reducing guesswork to improve confidence and predictability for all parties. The fundamental principle in collaborative contracting is trust. Trust established through transparency. Trust through setting aside the relentless pursuit of maximizing profits or defending against profits, depending on what side of the contract you're on. So collaborative contracting, what we're talking about here is truly an early engagement and a partnership. But how to engage in successful collaborative contracting is in itself an art. From an owner's perspective, it really needs to be used for the right projects by conducting a thorough procurement and options analysis and market testing and assessing organizational readiness. And once it has been committed to, it needs to follow through with that commitment to once the decision has been made to proceed by investing in the right team with the relevant experience and expertise, and tailoring a delivery framework that effectively aligns incentives. Project incentives and interest alignment is fundamental. Careful contract and procurement drafting is very much purposeful and needed. Set the right expectations with the contractor as early as possible, as well as including appropriate off-ramps to provide flexibility to pursue or pivot different delivery status or a different delivery methodology when appropriate. Understand that contractors must make profit. Creating a system of endless risk transfer and limiting compensation do not translate to the tone of collaborative contracting. Although the procurement is heavily determined on subjective and qualitative analysis, this doesn't just throw price into the wind. The project will require systems in place to ensure accountability of all elements of pricing. From a contractor's perspective, what collaborative contracting really obligates contractors to be is realistic and transparent about their pricing and profit targets on the project. Layering profit and hiding profit, whether it be in traditional ways or more creative, dubious ways, will result in the breakdown of that relationship and the overall project. The contractors need to pass that level of accountability, that level of relationship building and transparency down through the entire construction pyramid so that everyone working on the job is embracing these major principles. What we need to do is focus in a meaningful and logical way about risk transfer. Make it purposeful relative to the actual project and the actual risks of the project, and not just follow blindly corporate guidelines as it relates to risk transfer. Communication and early intervention are key. When things appear to be heading in the wrong direction, deal with it now, deal with it in a transparent way, and deal with it quickly. The outcome of this trust building through collaborative contracting should be, and is always the goal to be, an alignment of project interests and a trustful, reliable relationship where both sides feel that the success of the project is paramount and that they can rely on one another to be treated fairly in the event of an unforeseen or troublesome situation being encountered. So why am I talking about collaborative contract today? Well, there's a lot of buzz about collaborative contracting, most particularly in Saskatchewan. Saskatchewan, likely more so than our neighboring provinces of Manitoba and Alberta, and at least in step with BC and Ontario, is seeing honest and innovative steps in both its private or its large-scale private and public sector procurements to utilize collaborative contracting for major projects. Industry has stood up and said, we want to see these types of contracts, and governments and large-scale developers have listened, and they're giving this honest effort to attempt to use these outside of the traditional competitive bidding tensions. So the first form of contractual or collaborative contracts is certainly a buzz that we're all very familiar with, this idea of IPD, integrated project development, as well as other spin-off methodologies that are rising out of integrated project delivery. And so I'm going to take a couple minutes just to explain what is IPD and what are these other spin-off principles, just so that we all understand what it is. And so what is it? It's an approach that integrates people, systems, business structures, and practices into a process that collaboratively manages risk and processes of all participants to attempt to optimize project results, increase value to the owner, reduce waste, and maximize efficiencies through all phases of design, fabrication, and construction. Really, what it is a collective sharing of risk in a very open, transparent way versus each and individual member of the team carving out its own little area, their own little discernible scope and associated risks. So the key components of a traditional IPD engagement is a multi-party contract that has at least the owner, the primary or designer or prime consultant, and a primary builder or prime contractor. In this case, there's a single contract amount, which includes both a contingency as well as a profit pool, which is at risk with the overall price, estimated maximum price, as we see on the screen. What the fundamental portion of the IPD and sharing of their risk and attempt to align project interests is this fundamental notion that the cost of the work is guaranteed to be paid by owner to the prime consultants and the prime contractors, and throughout the construction pyramid, subject to audits for the same. This at least provides some certainty that contractors will be made whole in the event of some type of catastrophic execution of the project. We also are seeing a shared savings if project delivered under budget. So there's further incentive to earn more by bringing the project in on or under budget, as well as potentially early. It's really is an intentional creation of collaborative culture. So as the picture on this slide essentially indicates, the breakout of the financials for any type of IPD arrangement is that as the cost of work increases, the contingency and profit pools will diminish. In this sense, the IPD contracted terms will always be made, or the contractor teams will always be made whole from the payment of the cost of work, even if it's well in excess of the original budget. However, their ability to earn a profit will decrease if the cost of the work erodes those buckets of money. In that sense, we're starting to see an alignment of interest between the contractor and contractor teams and the owner. Although we may not be seeing much in the way of true formal IPD projects in Saskatchewan, we are seeing many of these principles and elements of IPD relationships and contracting leak into projects across the province. One of such examples within our large industrial mining sector. We are seeing the creation of an IPM more frequently than prior. IPM being an integrated project management team, which is essentially a management system that establishes a widespread team in lieu of just a sole traditional owner team. That shared accountability, that shared network, that shared professionalism and utilization of expertise relates itself very well to these large-scale mining projects that require a significant number of bodies and a significant number of horsepower to get this done. In this sense, the integrated project management team would be tasked with a collective responsibility to make the best case decisions on behalf of the project with an overall best interests in mind. However, I'd say the most common example of IPD principles being used in Saskatchewan today is the inclusion of IPD principles within construction management or reimbursable type contracts. These are elements in contracts that we're all very familiar with and frequently see CCDC 5B contracts being floated within the markets. We are seeing a push for more and more transparency in these types of agreements to encourage earlier and more collaborative engagement during the early development of a project versus until winning much later in the process. The transparency in that process leads to defining costs as true costs, such that contractors are being made whole, but are not realizing much in the way of unrelated overheads or profits outside of the predetermined and mutually agreed profit pools. Related thereto, we are seeing incentive plans and other contractual mechanisms being used to better align project interests, which eliminate the traditional approach of owner maintaining 100% of budget risk and incentivizing contractors to make more money the more pricey and longer the project goes on. The other form of collaborative contracting that we're seeing an extensive amount of uptake in Saskatchewan is this notion of progressive design build. Previously we'd seen almost no progressive design build in the commercial construction space, and now we're seeing significant as well as modest sized projects being rolled out by all levels of government across Saskatchewan. Again, progressive design build in itself could be a topic for a very interesting multi-hour presentation, so I'm going to try to boil it down in just a minute here. I think most are familiar with design build contracts, whereby the design and construction services are contracted to a single entity known as the design builder. In that case, the design builder is responsible for all work on the projects, often providing a turnkey solution to the owner. Although the use of subcontractors to complete more specialized work is common, the design builder remains the primary contract and primary force behind the work. The common challenge with this approach lies in the transfer of risk from the owner to the design builder following the procurement of the project. Contractors are often hampered in their execution of the work by unknown conditions, which often result in inadequate access to the project site before being submitted the response, or frankly, too much upfront investment to truly understand the risks of the project. The progressive design build model features a collaborative approach between the owner and the contracting partner during the early stages of projects, such as project requirements and design work. It introduces additional steps that enable the owner and design builder to progressively develop a design solution collaboratively before jumping directly into detailed design and construction. The procurement under a progressive design build model is very similar to that of a construction management model, in that it relies heavily upon the qualitative elements of the bidder. In that sense, their bench strength, the resumes of the professionals being used, as well as relevant experience for past project execution. In this sense, instead of having a design builder submit a design that or a design idea that they've come up with on their own based upon an authority published statement of requirements, what we're seeing is a true collaborative development of the design at the outset, so that there is no guessing as to whether this is what the owner actually wants out of their project. So these are two examples of very progressive collaborative construction and formal collaborative construction models that we're seeing in Saskatchewan these days. Why are we talking about it within the safety context? And I think there's a really interesting opportunity here, in that health, safety, environment obligations and collaborative contracting really presents a different opportunity, or an opportunity to do things differently than they're traditionally done within commercial construction. From my years working in the construction industry, I think it's fairly clear observance that the biggest impact in progressing and evolving safety within the industry nationally is arising out of the large-scale oil and gas and mining industrial sectors. The commentary behind this is often simplistically summarized as this: these large, profitable owner-developer companies understand the risk of safety, the culture of safety, the psychology of safety, and the promotion of safety, because they are willing to pay for it. It is often criticism of commercial construction versus industrial construction that owners in commercial construction, and I'm talking about owners in the sense of the contracting world, not owners of businesses, are just not willing to pay as much for safety as they are in the industrial sector. And perhaps that is true. And perhaps that is true, although it is likely more derivative of the contracting models and competitive tension used in procurement. When budgets are tight, especially in competitive lump sum bidding scenarios, this creates incentives to contractors to slash budgets. And one area that budgets can be slashed, and sometimes are slashed, is within the health safety budgets of project execution, thereby diminishing the resources and attention to safety on the work site. Further, owners are typically turned off in allowing large safety-related budgets if there's any thought that these are massive hidden profit generators versus actual costs related to health and safety that will result in impacts to betterment of safety. Within the collaborative construction space, I think there's this really solid and sincere opportunity to flip this concept on its head. If owners and contractors are able to work together to identify and isolate the true cost of health and safety for a project and make it a reimbursable component of the project that isn't a hidden profit center, owners may be more willing to fund initiatives, programs, equipment, and other impactful elements within health and safety. I'm very hopeful that contractors and owners, especially government owners, can look at these collaborative contracts with a renewed focus on safety to start closing the gap between our industrial construction sectors and our commercial construction sectors. There's a comment in the chat here that talks about, does contract structure allow an employer to delegate legal responsibility or safety? So I think it's a great question. Broadly, we understand that safety and safety responsibility flows with the contract obligations as described within the contract. So in some circumstances, an owner, developer, owner of the property or the project may maintain overall safety responsibility pending upon kind of the transfer of that prime contractor or constructor title that is determined. And that all has to do with overall care and control of the work site. In a traditional kind of run-of-the-mill contract, we would see the owner pass that responsibility down to the general contractor, who then would maintain that responsibility throughout the life cycle of the project, with major subcontractors working under them, subject to their rules and their governance of health safety on the site. I don't necessarily think the collaborative contracting models necessarily change that risk transfer of legal responsibility for safety. But what it does, I think, has a very good opportunity of changing the direct understanding of budgeting and payment for safety, and really, doesn't just throw safety within a large bucket of, you get this final project for 20 million bucks and included in there is safety somewhere. We're getting a much more purposeful, transparent situation saying, we want you to pay for safety. If safety is important to you, we are giving you an opportunity to pay as much as you want for safety. And none of that money that you're paying for safety is actually going to leak into our corporate profits, are going to leak into paying for better light fixtures. It has this very transparent manner of allowing owners the opportunity to promote safety on a site. So I think that's primarily the part of the project, or the part of this presentation, that I really wanted to focus on, as with respect to collaborative contracting. It's something that we're seeing more and more frequently in Saskatchewan. I'm sure it's something that every person on this at this particular meeting and conference is aware of. They're hearing about it, and so in such a brief time, this is as best as we can to describe it. And I think the main takeaway for this audience of construction safety professionals, and those that have a particular keen interest in construction safety, is that when possible, in these collaborative contracting situations, let's try to be flexible. Let's try to promote the ideas to owners that, hey, if we're doing this transparent process, do you really want to put or do something extra special for safety on this particular site? And how can we do that? And how do we really try to emphasize our commitment to safety? I don't want to go down in this particular chat, and I'm not prepared to go down this particular chat with the alignment of kind of ESG initiatives across, I think, globally across corporations. But this is another perfect example of, as owners are starting to think about how to create a more robust ESG portfolio, that health safety within their infrastructure projects is a great way of doing it. And collaborative contracting gives them a very clear direction from a high level ESG principle down to actually actionable real results. And they're not doing it in this kind of black box budget that a traditional lump sum project would have. So just some ramblings there. I think we want to move on to our second topic, which is the drug and alcohol legal update that was being requested to kind of review. And so I will say we'll use this remainder of our time to discuss any updates to drug and alcohol in the workplace laws over the last few years. However, I would note that there hasn't been much in the way of updates to the core laws of Canada or in Saskatchewan. And so over the last 2 years, I think we're seeing a little bit more evolution and some subtle understandings and clarifications throughout kind of policy development and large scale ownership coming through. However, there hasn't been fundamental jurisprudence, fundamental legislative changes that really make kind of a substantial difference within how we all collectively understand the current status of drug and alcohol laws. So I would guess that most to all of the audience here today is very fluent in drug and alcohol kind of laws, drug and alcohol in the workplace policy drafting, and the limitations and implementations of the same. So for those of you that aren't incredibly familiar with it, my apologies, as I'm going to do an incredible oversimplification summary of it in a couple minutes here. So when it comes to drug and alcohol in the workplace, it all has to do with impairment, not whether the substance being ingested is legal or illegal, but rather, if there's a potential impairment as a result of the ingestion of that substance. And this was something that was a very large misconception when Canada moved to a legalized cannabis situation. There was employees across all industries, across all provinces, that had this misconception that because it wasn't illegal anymore, that they could ingest recreational cannabis and attend the work site and it not be an issue. I think we're all very aligned now and understand that that is not the case. And really, if it's an impairing substance, there has to be some parameters and limitations around it as it relates to the workplace. So if impairment is the main principle, the connectivity of impairment to the workplace is all about being fit for duty. The concept of being fit for duty is addressed throughout OH&S legislation, collective bargaining, and our common law jurisprudence. So the vast majority of laws and legal evolution in the area of drug and alcohol in the workplace impacts relate primarily to the legality of testing. And in short, an employer really only has the authority to test in very limited circumstances. And frankly, it almost always is routed in, first and foremost, safety-sensitive positions. So the employee must be in a safety-sensitive position, and a kind of a broad definition of that is simply that being in a role where impairment could create an elevated risk for themselves or others around them. We see that that is kind of the general sense, but just because somebody's in a safety-sensitive position does not necessarily mean that they have they have to be tested, or they must be tested, or must agree to be tested at any time at the employer's will. There's very limited circumstances where testing of safety-sensitive personnel is permitted. So the first is pre-employment, pre-deployment, pre-access testing, which is fairly commonplace in remote work, camp work, and in our industrial mining sectors. And really what this is again just kind of that base test that comes in, and again that testing still has to be linked to a safety-sensitive position. Reasonable cause or reasonable suspicion testing really relates to, again, individuals in safety-sensitive positions that are demonstrating signs of impairment. And so in these circumstances, keen observation would say this person's not acting as expected, and we would like them to submit a test to see if it is as a result of an impaired substance. Next, we have this idea of a post-incident testing. And again, post-incident testing isn't as simple as there was an incident, you must test. I think the law has evolved and requires some level of an investigation and some critical analysis to determine whether impairment could have played a role in the incident, and whether that just being perhaps related to a potential avoidance of the incident or a potential mitigation of the impact of the incident, but for the fact that there was a potential impairment in place. A return to work testing, this is different apart than the pre-employment pre-access testing. This is really when an employee has been off work as a result of some type of substance-related leave and treatment, and there's a gradual return to work process. There may be some permitted testings involved within that process. And finally, the hot topic from kind of, I guess, maybe about 5-6 years ago is this nebulous concept of random testing. How do we get random testing in the workplace? Because the outset was really owners, developers really thought this could result into a much safer workplace, but we have to balance that with kind of owners or rather workers' rights to privacy, rights, and other charter rights that we're seeing here. And really, I think the law was well settled at this point in time that in order to implement a random testing, there has to be a systemic and overarching issue with impairment within the kind of collective industry and specific to that area. And such, it sets a very high standard and a high bar to be able to legally implement a random testing program. Again, I understand that this is very much a simplification of the nuances and very delicate details of drug and alcohol laws in Canada, but nonetheless, here we are, and just trying to set the kind of the table stakes here for our discussion. So the case that I'm really interested to talk about today is this BLS Asphalt Inc. Case. And before I get into it, I think the first thing I want to be clear about this particular case is that any comments made about it are made in all respect, like are truly made with all due respect, and they're not to be a criticism of the court, the lawyers involved, the company or the company's owners, any of the other employees of the company, and the investigators involved, or the individual who tragically passed in the matter that we're talking about here. I would again expect that probably most of you are familiar with this case, or at least familiar with the fact that this case existed, and most notably about what you're familiar about it would be the clear example of prosecution of OH&S offenses carrying significant penalties for business, and really, what we saw was a prosecution of this business and a heavy fine being administered against them. However, I don't think that's the most interesting thing about this case. It's not the result of the fines and the clear message made by governments that OH&S breaches are going to be punished severely. But I think the most interesting thing about this case is actually the court's refusal to give any weight to the potential impact on a breach of the employer's drug and alcohol policy and the potential impairment by the employee who died in this incident. So, again, very brief summary here is, in short, this case deals with the Saskatchewan company who's fined a total of $350,000 after a worker at their facility died as a result of becoming entangled while clearing the chute of a conveyor system. The company was found guilty of 2 violations under the OH&S regulations. I think the other facts that are really relevant to our discussion today is that post-mortality, there was a drug and tox screen done that found there was alcohol still in his stomach and there was illicit drugs in his system, which indicated, a very immediate or proximate use of these drugs, to the point that it was of the same day of his death. The other important, I think, facts that are to keep in mind here is the other employees which were with the individual the night before, so potentially were out drinking with the employee the night before, and were with that individual all day, were never drug tested following the incident. And they indicated that there was no signs of impairment from the individual prior to him hopping up on the conveyor belt and trying to clear the jam out by kind of lodging his leg in there. From an outside and retrospective point of view, it's one of these situations that had the employees also been drinking or taking drugs that day, it would be a very negative or detrimental position for them to be admitting the same of it, or admitting that they observed signs of impairment but allowed this person to continue to keep working. And so we have indices of a potential flawed investigation at the outset that these individuals may have had some self-interest in keeping those facts that would be really relevant in the prosecution and judgment of this circumstance to themselves. And so that's how we kind of paint this overall this overall conundrum that we have with this case. So what we saw in the analysis of the judge in the decision being published is that there really is no consideration or weight to the post-fatality drug and alcohol test. And so I think attempted in that company's representation, counsel argued that the behavior, decision-making, and actual actions of the deceased employee was a result, or in the very least, were affected by the drugs and alcohol in his system, and that the incident and death would not have occurred but for this employee breaching the corporate drug and alcohol policy. And this is a train of thought that's basically say, we have this employee, we have a drug and alcohol policy that is meant to prevent people from attending to the site while potentially impaired, and that this person knowingly breached that policy and thereby created this additional elevated risk that led to his actual demise. The court didn't put much weight into this argument, and this is fairly problematic, I think, for most employers. We have a circumstance where an employee has attended the work site, knowingly breaching the drug and alcohol policy, with drug and alcohol in his system, is very likely impaired, and is in an accident. But instead of the court determining that this was a rogue actor, going off on their own and breaching the kind of the corporate policies that are meant to prevent it, the court has potentially created a precedent in disregarding the same. And so, it really creates a very interesting conundrum for employers to basically say, well, look at this case. We can have a diligent drug and alcohol policy. Someone could still attend the site impaired, get hurt, and we are still going to be 100% liable for it, even though we have rules in place to prevent it. And so I think the major takeaway principles of the case are as follows. When it comes to drug and alcohol testing and safety, proper records and proper training is absolutely critical. Though this employer had a drug and alcohol policy, it certainly wasn't a blue chip one. It wasn't the industry leading drug and alcohol policy that may have been able to do two things. One, most importantly, prevent the impairment related incident prior to occurring. That being, there could have been an early identification of this individual and had this, had an intervention earlier. There could have been robust policies and rules that would allow for the reporting of this person and essentially prevent this accident from happening. The other thing, which is probably secondary to maintaining someone's health and safety, but also from a corporate viability and corporate ownership point of view, is it allows that robust due diligence defense in the event that there is a rogue actor out there that attends the site in light or in breach of these circumstances and has an accident. A very robust policy that is enforced and taken very seriously provides further and further confidence in our ability to roll out a due diligence defense that may not be disregarded by the courts. The other main thing that we would really emphasize is a very thorough conduct of an investigation and to engage as much assistance as needed for a widespread, detailed, thoughtful investigation in a very immediate fashion. Facts that may not seem relevant at the time may turn into very important and crucial insights later on. And I go back to kind of the individuals that were with this employee that died kind of the night before, all day of. A very thorough investigation may have asked for them to go get drug and alcohol testing. And I have no idea if they were impaired. I'm not speculating that they were or weren't, but we would know for certain had the investigation considered that and went through that path. So I think those are the main kind of points that we want to talk about. This very interesting situation where, we have physical evidence of alcohol in the systems, very, very relevant physical evidence of illicit drugs in this person's system, kind of post-mortality. And we have the court basically saying, even if this person was impaired, whereas, you company are still responsible for the incident that occurred, and this person's potential impairment isn't going to mitigate the liability and the consequences of that liability. So I think it's a very stark reminder to companies for that. I think I'm just going to run through our practical suggestions of drug and alcohol policies in light of kind of those takeaway points from BLS. When it comes to drug and alcohol testing and safety, proper records and proper training is absolutely critical. It's important to record all safety incidents and near misses. This could be helpful in establishing that workplace is safety sensitive, and it could also, in rare circumstance, justify an elevated form of testing. So, for instance, the implementation of random testing. Managers should also have clear training on the parameters of drug testing. It's important that they do not have absolute authority. They're restricted to safety sensitive and to the circumstances we discussed, which justify a test. Meticulous records should be kept about why an employee was or was not subject to testing. A manager observing the basis for reasonable cause should do a complete report on who, what, where, why, when, and how the situation and why they think that testing is necessary. It's crucial to get the details down as soon as possible to avoid any type of memory issue. There are lots of variables in drug and alcohol testing, and that is why it's important to have a step-by-step procedures and protocol that are followed in each testing scenario. That doesn't mean that we have to be inflexible, but there should be a very robust guideline for employees to follow. Take the discretion out of it as much as we can. Make sure to have a larger occupational health and safety policy that identifies and reduces risks in the workplace broadly, but the drug and alcohol policy is one tool that many employers will need to utilize. Make sure to regularly train supervisors and managers on your policies, most particularly your drug and alcohol policies, as well as employees, and document that training, as again, that affects your ability to rely upon a due diligence defense. Last, drug and alcohol policies can really vary, but the basic recipe is outline what is prohibited in the workplace, outline the consequences of a violation, outline the accommodation process will be utilized for addictions, disabilities, and which we didn't discuss at all today, but that's a very important consideration when we're dealing in the area of drug and alcohol. Outline the who, what, where, why, when, and how of drug and alcohol testing. Make sure to address all impairing substances. And it's helpful for your drug and alcohol policy to be drafted or reviewed by professionals outside of your particular company, including by learned lawyers. Last, where you have a policy, there are certain extra steps to make sure it is upheld if employees or a union challenges it. Make sure that employees know about the policy. Make sure the disciplinary consequences are clear in the policy. Have your regular training. Have employees sign policies confirming they understand it, and consistently follow the policy. Every time we deviate from the policy in our practical day-to-day operations, we're making our ability to rely upon that policy and demonstrate that that policy is taken seriously, we're diminishing that. Here we have a final practical suggestion is to train employees and staff on issues surrounding legal cannabis. There should be a clear message that legal cannabis is just as prohibited as legal alcohol. You can't have it at work. You can't use it before work. You can't be impaired from it, most particularly as it relates to safety-sensitive positions. If you already have an extensive drug and alcohol policy, make sure it still apply to legal cannabis. Some policies often refer to illegal cannabis, and in those cases, those would be very much outdated. So that's what we have. I have successfully stopped talking prior to my deadline, so that's a win for me. Feel free to pop comments or questions within the comment section, and happy to try to handle those in the next couple minutes. So the question Richard has asked is, how do you comply with OH&S regulation 716B if the only available anchor point is at foot level on a leading edge? I do not have the answer to that question. I'm sorry. I'm not. I don't have the practical ability to answer that. I would hope that potentially within the community of safety professionals that have project site specific training and experience, perhaps they can help you out, Richard. From a legal point of view, I'm not sure if I can help you there.
Thanks, Robbie. That was a very interesting presentation. I actually have a couple of questions for you.
Sure, I can do my best.
So I'm going to go back to when you were talking about the collaborative contracting. Do you see a role for an owner's rep, whether it be a third party or somebody that the owners themselves hire in this process?
Oh, for certain. I think, you know, most particularly in large scale projects, doesn't matter if we're talking government or private, we're seeing the role of owners reps, you know, being utilized more and more frequently. And that has to do with a couple things. It has to do with the availability of like experienced project management personnel within the province, you know, that they're sometimes difficult to recruit and train. And so, you know, many, whether it be government entities of every level, you know, federal, provincial, or municipal governments, or large scale private developers, simply just don't have the horsepower to manage sophisticated projects from an owner's perspective themselves. And so an engagement of an experienced owner rep contractor is often needed, and frankly would be recommended. You know, the concept, or kind of the comment we made is, you know, if you're going through this route of collaborative construction, like, your owner obligation here is to ensure that you're committing the resources, the time, attention, and staff to actively participate in that. So highly recommend an owner representative if you don't have the horsepower or experience internally to address it.
Okay, we have a question here from Yves Carrier. Can you see it there on your screen, Robbie?
Yes, I can. So any comment or experience helping companies on the change management dynamics of implementing a real-time fit for duty testing risk mitigation tool. I don't have any firsthand experience on that. You know, we have some very experienced safety litigators and safety professionals that we work with within our firm that are probably a little bit more experienced with this particular question. So I would say on the change management dynamics of implementing a real time, I would think what we want to do is, like, my overarching concept on this and principle to address this would be communication is key, and advance notice as much as possible is key. And that doesn't matter if you're working in a collective bargaining environment or, an open shop type environment. And really what you want to do is ensuring that if you're changing things, how we go about analyzing people's fit for duty test is to be as open and transparent about it as possible, to give people as much notice to be able to comprehend it and have an opportunity to consult and discuss and engage about it prior to it happening. And so, if we're starting to see, or companies are starting to see instances where fit for duty is really being questioned, and I'm not talking just drug and alcohol impairment, but also, from an injury point of view, from a capability of, can they safely do the tasks required for their job? I would suggest that what you do is create a community of professionals that, you can refer these people to go see and ensure that they are fit for duty as required, and that we are, making it very well known about what the company's intentions and processes are. It's somewhat of a soft answer. And if, we want to have a more robust conversation about kind of specific things that you have in mind, I can certainly make a suggestion for some individuals for you to talk with.
And we have another question here from Stephen. He says, if an employee is found in violation of the drug and alcohol policy and is terminated due to zero tolerance, does this conflict with human rights for wrongful termination disability, or does every case need to be looked at as a disability first?
I would say, it's a very good question. And this is the fundamental question and fundamental dilemma that many employers have, in that, we say there's a zero tolerance situation, and almost every single drug and alcohol policy is drafted with this idea that any breach will result in termination. We have to weigh that with the human rights disability situation, where there has to be some level of consideration and analysis undertaken to determine, does this person have an addiction, a medical disability as a result of their addiction, and has to be managed that way. There's some circumstances that a termination is warranted regardless of the disability, and that may be, a severe or significant incident occurs that, there's no ability that the employee and the employer could possibly maintain a level of relationship there. I would say, as a rule of thumb, every case probably needs to be looked at as a disability first, though.
Okay, I have one more question.
Sure.
I hope you don't mind, and I hope I'm not opening up a can of worms by asking this, but I'm going back to that collaborative contracting. I guess that must have stuck in my head there. Do you see a role for insurance companies and those issuing bid bonds within this process?
Very good question. I think they play a role within probably more insurers, more so than surety companies. They play a role kind of behind the curtains on both sides of that contracting negotiation, really to really assess what is the adequate and proper level of insurance here, and what is the right program for it. Is it an owner provided, paid for, run in program like an OSIP, or is it a contractor provided insurance policy? What are the right levels of limit? And in this collaborative contracting, where we probably have a sharing of the costs associated, or a flow through of the costs associated with it. I mean, we have to strike that balance where contractors are probably always going to push for over insurance, being that cost is get carried over to the owner, And, you know, the extra and additional and overinsurance there in that situation protects their liability in the event of some sort of catastrophic incident. And the owner has to balance that and to say that, well, we don't want to be underinsured because that's going to create an unnecessary liability and risk for everyone. But we don't want to be overinsured either, because that's just probably a waste of money. And so I think that's kind of the primary the primary commercial kind of value of bringing in insurance professionals to kind of help negotiate what is the right level of insurance and policies here to ensure that we're not under-insuring and creating risk, or over-insuring and wasting dollars.
All right, thank you very much, Robbie. That was great information and a lot of detail that I'm sure is going to be valuable to all of our members. If anybody has any questions for Robbie, you can contact him via his website, mltaikens.com, and that's in our chat, and we have it up on the screen here as well. That's mltaikens.com. Thanks again, Robbie.
Thank you. Great. I hope you guys have a great rest of your conference, and I'm sure there's going to be a lot to learn. So thanks again for the invite, and have a great day, everyone.